Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome back to our latest private clients podcast, Trust Matters, where we are exploring trust issues in Australia. Today we're going to talk in episode 3 about beneficiaries and their rights to information. This is an area, again, that we're starting to see a lot more discussion and a lot more disputes flowing from. Again, there's been a number of cases in the last 5 or 6 years which have really focused people's attention on what a beneficiary is entitled to. It's probably changed the norms that existed and the thoughts that existed before those cases were handed down. And it's really giving the beneficiaries of the trusts, if they're the right type of beneficiary, which we'll talk through, more rights to access information, which can potentially be a lever for them to then look at other ways that they can agitate issues in relation to the trust. In this episode, I'm joined with my colleague, McLean Edinger, from our team in Perth. He heads up our estate disputes team and does a lot of work in trust disputes, and we'll be really focusing on these matters around trust disputes. Welcome, McLean.
Hi, Will. Thanks for having me.
Pleasure as always. Beneficiaries and rights to information, McLean.
Look, it hasn't really been an issue until probably the last 10 or so years. I mean, a lot of the trusts that were created in the 80s and the 90s were by mum and dad, who effectively had control of the trust and really were making a lot of the distributions to themselves. And obviously with these family trusts, there's a very broad class of beneficiaries, but they really didn't ask a lot of questions of mum and dad. They didn't really ask for the right to access many documents, because at the end of the day, they just saw it as mum and dad's asset pool and that they were in control. But as times have changed, obviously we're aware of the aging population, and that there's a lot of wealth that's been tied up in that aging population. So we are starting to see that a lot of the people that created these trusts are starting to pass. And then the important thing is who is to succeed in those controlling positions as appointor and trustee. So what we're now seeing is that, if mum and dad have had 4 kids, it may be that they pass control upon, that mum and dad pass control upon their passing just to 1 or 2 of those children. It then becomes this issue of those who don't have control, despite being listed as a beneficiary, potentially one of the primary beneficiaries of the trust. They are starting to ask some questions of, well, what's actually in this trust? What assets does it hold? What's the income that the trust earns? And as we know,
they might have traditionally been kept in the dark a little bit in terms of when mum and dad are in control, and now there's that concern about what's happening next.
I sort of think in the olden days, if I can use that phrase, I don't think kids would sort of probe too much of their parents as to what they were worth and owned. And I think there's a lack of understanding amongst a lot of people as to how trusts work. So they didn't really have a good understanding of what mum and dad had in the trust. And then because of that trigger of change of control, they may have thought their entire life that it was just a fixed interest that they were going to get 25% of as one of 4 kids. And all of a sudden they get told by their brother as trustee or the lawyer dealing with the family's affairs that, oh no, all of the assets of the family are held on trust. And it's this question of, well, what does that mean? And the first thing that people want to know is what is actually in the trust. So that's why
what is my share of the trust?
Yes, which, and as we'll talk about, there's no fixed entitlement that a beneficiary has in the trust or to the assets that are held by the trust.
It does often bring about a lot of discussions and a lot of, I think, that uncertainty, that concern about, well, how is it going to get dealt with if it's discretionary and I don't have any control in it? How do I know what my entitlement is? What is my entitlement? Do I have an entitlement? What are my rights as a beneficiary? And traditionally, it may have been the case that was just sort of washed away, but now with these more recent cases, McLean, we're really starting to see a lot of those beneficiaries feeling almost empowered, or they're getting advice that they can ask those questions. They're getting advice that they can really get a better sense of what's in the trust and how decisions may have been made in the past and who's got benefits in the past, and then start to probe more about whether those decisions were right or wrong and are properly considered.
Yeah, I think that's absolutely right. The wave of case law in the last 5 to 10 years, which has come about because there's a lot more trust disputes between family as the control is passing. Um, the courts are really clamping down on the conduct of trustees, but they're also trying to make really clear the legal principles that surround, obviously, exercise of trustee discretion, but also other ancillary issues such as the beneficiaries having right to request and inspect the documents and the information of the trust. And I mean, really, until recent times, basically, and as is the case with a lot of trust law, it's not based on statute. It's largely controlled by case law. And the old English case law basically said that a beneficiary of a family trust effectively had a proprietary interest in the trust and its assets and the documents of the trust. And therefore, for a long time, it was sort of thought that, a bit like being a beneficiary of a deceased estate, that effectively a beneficiary could request access and inspection to the trust documents from the trustee, that they had basically a fixed proprietary right to inspect those trust documents. But then there was a decision sort of in the early thousands from the Privy Council in England that effectively said, well, that's not right. At the end of the day, if you're a beneficiary of a discretionary trust, you don't have any fixed interest in the trust. You just have a right to require the trust to be duly administered, but it's not as if you have a fixed interest as you would if you were a beneficiary of a will. And so really it comes back to that the court has this overarching jurisdiction and power to supervise the administration of trusts. And the courts have said, and this has been adopted in Australia in recent years, but really the key cases only came out probably 2021 in New South Wales and Victoria, that it is actually at the discretion of the court upon a request being made by a beneficiary of the trust as to whether access should be granted. So there's no proprietary interest. It just comes back to the courts having this discretion upon a request being made to the court as to whether access should be granted, and obviously the trustee then being compelled to provide the information to the beneficiary.
If I'm a trustee of a discretionary trust, for example, and I get a request from someone who is a beneficiary of that trust to provide them with the trust documents, I don't necessarily have to give that to them. I would get some advice about whether I should or I shouldn't. But if I'm still unsure after I've got that advice, I've also got the ability to go to court and ask the court to provide advice about whether I should or I shouldn't do that. Likewise, the beneficiary has got the ability to go to court and ask the court to give advice whether the trustee should or shouldn't. So there's avenues for both the trustee and then also for the beneficiary as well.
And it's, we obviously act for a lot of trustees and beneficiaries, but when you're acting for a trustee, it is difficult because on the one hand, if you're open, transparent, you disclose everything to the beneficiaries, particularly those who may have a clear entitlement or, expectation of a distribution or received distributions in recent years.
So there might be someone who's named as a specified beneficiary or a primary beneficiary, as opposed to someone who is more broadly caught up in a class of beneficiaries, such as a cousin or a niece or a nephew.
Yes. And it really comes down to, just because you're in a, so say that example I've been talking about, mum and dad have passed, they've got 4 kids, and then one of the children is the trustee. I mean, it's understandable that the 4 kids or the 3 others who don't have control of the trust would expect to be equally provided for as that sibling who has control. And so if that sibling that has control is asked by the other 3 to provide information and documents, if they don't provide it, it's obviously going to arouse a lot of suspicion on the other 3 as to the conduct of that sibling. Are they acting in a way that's to their own self-interest, to the detriment of the other 3? So it's that fine line between saying to a client who's in that position as trustee, well, you're not obliged, you don't have any actual clear requirement to provide it unless the court orders you to do so. you have a discretion to exercise effectively. But if you don't provide it, then clearly the only avenue available to the beneficiary is to actually make an application to the court. It's going to obviously arouse suspicion on their part. There's then a breakdown of the relationship potentially between the four kids, which can lead to a whole range of issues, not just about access to documents, but also about the conduct of the trustee. And
that might bring up the matters that David was talking about in our last episode in terms of that exercise of trustee discretion. If it then shows that there's been a pattern of distributions which may not have been properly considered, for example, this is really just potentially opening up the door for that type of examination.
Yes, it's just going to mean that everyone's going to start to put a microscope on the conduct of the trustee and what they have and haven't been doing. And I mean, look, I think it's important to sort of note that there's been a lot of experts in this field, and I certainly agree with this, that have sort of been critical of the fact that the courts have adopted this position out of the Privy Council, that it really is at the discretion of the court as to whether a trustee is going to be ordered and required to provide disclosure to beneficiaries, because it effectively means that there's a lot of uncertainty. You have to make an application to the court, engage lawyers, the trustee needs one, the beneficiaries need one, everyone incurs a huge amount of fees rather, and then you're going to have to file evidence, take 6 months, and it comes down to a judge who just has to form a view as to whether, according to the principles and the facts at that time, whether the documents have to be provided or not. And it sort of means that it's easy for a trustee to hide behind that and just say, well, look, I've been advised that I don't have a fixed, or that you don't have a fixed interest and there's no proprietary right to the documents. I've been advised I don't have to provide them to you. Only if I get ordered by the court, I'm not going to provide them to you. And really, it's easy for a trustee to put up a roadblock. And then it's an expensive, complicated application that the beneficiary then has to make. So that's why there's been a few that have been critical as to, well, it's at the discretion of the judge, but should there be some clearer principles in terms of there are certain documents, very standard trust documents, for example, that if requested by one of the primary objects, primary beneficiaries or specified beneficiaries of the trust, if it's a good faith request for a proper purpose, it should be provided. And in my view, I think that would actually be a lot clearer.
So if you think about a situation where a beneficiary's got a right to the due administration of the estate, how do they actually see that the estate or the trust has been properly administered? One of the fundamental aspects of that is looking at the financial statement. So if you're a trustee and you get a request from someone who is named as a specified beneficiary, where the trust is set up to primarily benefit those named or specified beneficiaries, the better course of action is probably to agree and to comply with that request, subject to checking that there's nothing in those financial statements, for example, that might be commercially confidential or could somehow impact on other beneficiaries, because that's probably where we're going to end up if it goes before a judge, and the judge is most likely, based on that recent case law, going to say, because they're a close beneficiary, because what they've asked for is a fundamental trust document, they will probably order that the trustee provides that information to that specified beneficiary, as compared to a situation where you're dealing with a much more extreme beneficiary who might be an extended relative and they're asking for something that might be commercially in confidence, for example. That's where you've got a much lower risk of a judge saying, yes, you should hand that over, because of that more distance between the beneficiary and the more specificity around what's been asked for.
I think that's certainly right. So as much as I just explained, there's some uncertainty there, and there's certain experts that have been critical of the court's approach. The courts have tried to be proactive in saying that sort of the key two factors they'll take into account if a beneficiary is applying for documents is basically whether that person is a beneficiary, and more particularly a specified or primary beneficiary of the trust. And then the second thing is the scope of documents that has been sought. And the courts have basically said, if you're really just requesting the core trust documents, trust deed, any deeds of variation, and the financial statements, generally, unless there's, the courts haven't gone so far to say there's a sort of presumption, but they've basically said, unless there's almost a good reason to the contrary, that if the beneficiary and the applicant can tick both of those boxes, then they'll generally order that it be provided. And there's certain case law out there where a beneficiary has made an application and cast a really wide net, asked for all sorts of things over such a long period of time. And the courts have said, no. And then they've come back and confined it right down to the trust deed, any deeds of variation and financial statements. And the courts have said, yes, you can have that.
Good. If we follow that thought process on, McLean, is there anything else that you would maybe say in closing in terms of key elements in dealing with these requests for information, be it if you're acting as a beneficiary, if you're acting as a trustee?
Look, I mean, from a perspective of a trustee, my view is, generally speaking, if you've got a reasonable request that's been made by the primary beneficiaries of the trust, particularly if there's no reason to be concerned about what you've done, and there's just a request for the trust deed, deeds of variation, financial statements, I certainly think that there's really no downside to providing it. At the end of the day, the trustees are there in a representative capacity, strict fiduciary duties. If there's ever an application made and you're before the court and you're not there with what they call clean hands, you're more likely to be criticised by a judge. Adverse costs orders the risk of being removed as trustee. So be reasonable, be transparent. And that also holds you to account as a trustee to make sure you're complying with your fiduciary duties. From the point of view of a beneficiary, it's basically the same thing. Don't ask for too much, just ask what you need to actually understand how the trust is being handled, administered, what the assets are. But it is a difficult position for a beneficiary because it comes down to the discretion of the court. And if you've got a sibling who controls the trust that you don't get on too well with, unfortunately, you are going to have to make an application.
And there's no guarantees, as we all know, in terms of making court applications. And even if you're successful in that application, it's not necessarily, to borrow David's words from our last podcast, going to get you the result that you want, which might be getting something out of that trust. So,
no, that's completely right. Just one other point I would mention. Obviously, in the last podcast, David talked about whether a trustee needs to give reasons for the exercise of their discretion. What a lot of beneficiaries try and do is ask for any records that go to basically the reasons or the deliberations that the trustee has made before it's come to its decision as to how to exercise its discretion. The courts have been very reluctant to order trustees to provide that. So it really comes down to the core trust documents. And if you stick to that and you're a primary beneficiary or a specified beneficiary, you're in good standing. And then it'll mean that, there's a good chance of getting some costs back as well.
Good. Well, thank you for that, McLean. Some very helpful words there for people to consider if they are in that situation where they're acting as a trustee, getting one of those requests, or they might be a beneficiary and want some more information about how that trust has been administered and are looking for ways to do that. So we'll close that episode on that note. And in our final episode next week, we will be looking at lost trust deeds. What happens if there is no trust deed? Does the trust fail, or are there other opportunities to try and keep that trust running? Thanks everyone for listening, and speak again soon. Take care.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.